SAA's business rescue practitioners are appealing a Labour Court judgment on retrenchments this morning. Now, in May, the court ruled in favour of unions eNCA and SAA in a bid to stop retrenchments. The unions argued there was no proper business plan or proper consultation, but a lot has happened since then. eNCA's Heidi Giokos has been following this story from the start. Heidi, good morning to you. So I think just remind us, because there's been so much back and forth over this in this fight, exactly what the heart of this matter is and why we find ourselves at court again.
Yes, indeed, Rebecca. So much has happened. I think eNCA and SAA have taken SAA and the business rescue practitioners to court for the second time. We know in Feb there was an application brought forward by eNCA, SAA and the South African Airways Pilots Association to stop the retrenchment processes announced by SAA business rescue practitioners. That application was dismissed on the basis that the court said that if the business rescue practitioners submit their business rescue plan, they can go ahead with their planned retrenchments. However, that has not happened. There's been extension after extension in terms of the business rescue plan being submitted, published and adopted. And this is when the unions went back to the courts in May, and they won that application. The court ruled that in order for the business rescue practitioners to make sure that the retrenchments take place and it's lawful and it goes according to the Labour Relations Act, they need to make sure that the business rescue plan is adopted. So that was a win for the unions, and this is why the retrenchment process was halted. But it seems as though the business rescue practitioners are appealing that decision, and they are saying that even though there needs to be fair labour practices for the staff at SAA, for all employees, there also needs to be fair labour practices for SAA and the business rescue practitioners. They are in a position where they need to implement these retrenchments. COVID-19 has exacerbated the financial situation at the airline, and this is why they've decided to appeal.
All right. Well, throughout all of this, the business rescue practitioners, Heidi, have been adamant that what they're doing is fair, that it's lawful. What has been their argument? How are they standing their ground?
Yes, indeed. So in their court papers, they are basically saying that their situation is very different and unique. Even though they received post-commencement funding, they did not receive enough funding to execute their business rescue plan. There's been a delay. This is why they've been granted 5 extensions to submit that business rescue plan. And they are saying that they need to execute job cuts. They need to make sure that they cut as much as possible, because for a new restructured airline, they cannot go with the current workforce that SAA has. So they are saying that the court needs to reconsider its decision to halt the retrenchment process and understand that the business rescue practitioners perhaps have a mandate that they need to go according to. And even though the plan has been submitted, it's not been published or adopted, and that's not their fault, basically, because the unions have tried to stop that business rescue plan from being voted on.
And the unions going as far as moving to stop a creditors' meeting last week, Heidi.
Yes, exactly. So last week, the meeting was supposed to take off, where creditors, all affected parties, unions and so forth were supposed to vote on whether they accept the business rescue plan or not. But a number of creditors, as well as the 3 main unions, eNCA, SAA and the South African Airways Pilots Association, indicated that they want an adjournment and they want to reconsider the business rescue plan. They've made it very clear they don't accept the business rescue plan in its current form. They don't agree that so many jobs should be cut. They don't agree around the business model in terms of how many flights should resume or how many flights should not resume. And they asked for an adjournment for the 14th of July. So that creditors' meeting will only happen then. So the business rescue practitioners were ready to kickstart with their business rescue plan, but creditors need to vote on that. And because there was a motion for an adjournment, this is why the meeting did not take place. So it's another delay in that business rescue plan from being adopted. And they are basically saying that this appeal is not warranted in the courts today because it's unfair labour practices, and they should be consulted, and there should be a proper business rescue plan on the table in order for them to accept it and to understand why so many jobs should be cut.
All right, so back in court today over this issue. Heidi Giokos will continue to keep an eye on that story for us now.